Hey guys, it's me, Asha, and I am back with another Ask Asha legal explainer. So this week I have two questions that I got from my Substack. The first is from Genevieve, and she is asking, what are your thoughts on the Supreme Court ruling regarding they're okay to send people to foreign countries and without due process? And the second one is from Michael, and he says, Hi, Miss Rangappa. Hi. I would like for you to please check about birthright citizenship. We know that the SCOTUS will be on the docket very soon. And he sent that earlier this week, and there was a decision that came out with regard to the birthright citizenship case today. And I wanted to talk about both of these because they both involve something called interim relief that is offered by the courts. And this is sort of a wonky procedural thing, but I think it's worth understanding. So, you can kind of understand the landscape of all of these decisions coming down because there's a lot happening. So, obviously, when a law is passed or an executive order is issued, the executive branch can begin enforcing it. Now, the people against whom it's enforced can go to court and try to challenge it. They can say it's illegal, it's unconstitutional, but litigation can take a lot of time. And so courts have what's called equitable jurisdiction. This sort of just means that they can exercise a jurisdiction in which they can sort of take into account notions of fairness. And under this equitable jurisdiction, they can actually stop a law or executive order from going into effect until the actual litigation is resolved and we actually know the final situation on whether the law or executive order is valid or constitutional. And the way the courts do this is that they will they can issue a temporary restraining order. This is immediate emergency relief, and they can issue basically a pause on the law going into effect, but it will only be temporary for about 14 days. And if they do, kind of a hearing where they listen to both of the parties and get deeper into the issues, they can issue a preliminary injunction. And that will basically pause the law from going into effect until you reach the final conclusion on the merits, until, the court finally decides a final decision on the actual issues in the case. What the court considers in giving both a TRO or a preliminary injunction are very similar, but I think there's four factors, two of which I think are kind of important to the cases we're talking about this week. One is a likelihood of success on the merits. So again, in issuing this interim relief, this is sort of just until the final litigation happens. They're not making a decision on the actual legal issues, but they are going to look and see which side has the better kind of legal argument, who's got the law more on their side. And so the court is making an assessment in this case on who's likely to succeed. And another factor that the court considers is irreparable harm. In other words, if the law is allowed to go into effect, what kind of harm could this cause? If the law isn't allowed to go into effect, what kind of harm would it cause the other party? In the case of the government, when it's trying to enforce something, then obviously the harm is whatever would happen to the party against whom it's enforced. And the harm to the government is, the harm of not being able to enforce the law. So this is sort of the background. These are interim measures. They're not sort of final orders of, based on the actual legal issues that are arising in the case. So with regard to the deportation case that Genevieve asked about, there are many deportation cases that are being litigated across the country. People are being removed under different authorities. This particular case arose in the District of Massachusetts, and it concerns people who are being removed to third countries. So countries that they are either not citizens of or from which they did not come directly. And it also involves the ability of people to challenge a removal to any country where they fear that they might be tortured. So, our Immigration and Nationality Act gives people who are being removed a right to basically articulate any claims that they believe that they might be tortured if they're removed to the country that they're being sent to. And this is also part of the Convention Against Torture, to which the US is a party. So, this is sort of our obligations under this international treaty as well as under our domestic statutory law. So, the Department of Homeland Security was removing people to places where they believed that they might be tortured and were not giving them an opportunity to raise these claims. And so, several people brought a lawsuit challenging this policy, and the district court in Massachusetts issued a temporary restraining order initially. And then, after hearing from both the government and the plaintiffs, issued a preliminary injunction. And just to note here, the preliminary injunction wasn't that the government couldn't remove people at all. The preliminary injunction basically said, before you remove people, you need to give them notice of the country that they're being removed to and give them a meaningful opportunity to raise any claims that they have a belief that they might be tortured if they are sent to that country. And that preliminary injunction went into effect, which meant that the government had to comply with those conditions. Well, the Trump administration was not super happy about this. And so they wanted a stay of the preliminary injunction. And this kind of gets confusing. I know that it gets confusing to me. So a preliminary injunction is basically a pause on the law going into effect. A stay of the preliminary injunction is a pause on the pause. So it's kind of like a double negative. So the Trump administration wanted a stay of the preliminary injunction, and this went all the way up to the Supreme Court. And this is what the Supreme Court issued on Monday. They granted the stay that the government asked for, which basically meant they got that double negative. They got the pause on the pause. And so the government is allowed to continue removing people without having to, give these conditions. Again, the litigation is continued. This is all about this interim relief, so it's not a final decision. But my takeaway, Genevieve, is that basically, if you look at those factors that I mentioned before, the law is really on the side of the people who are arguing that they should have a chance to get due process and notice and be able to make these claims. And especially, I think the factor of irreparable harm is on their side, because obviously if they're being sent to a place where they might be tortured, even if down the line, sorry, that's my cat. Even if down the line the litigation ends up being in their favor, how do you turn back the clock? How do you reverse that? How do you make that whole? And this is a government that may not even bring people back. And so this is what Sonia Sotomayor, in her dissent to this order, points out. And she says, the harm to the government here is just that they can't enforce their policy does seem to be outweighed. The bigger thing here, though, is that what's happening behind the scenes since this district court issued its preliminary injunction, which meant that the government was obligated to comply with it, they were violating it. They kept sending people to different countries without giving them the notice and opportunity to raise these claims as the district court order had required. And basically, in granting this stay, the government has rewarded that behavior. I mean, they haven't taken into account, even if the government won in the end, they were required to follow the law in between. And I will have more on that in my Substack because there's a whistleblower complaint that came out that basically details what was going on behind the scene. So it's not just that the government gets to continue, continue with its policy and potentially violating people's rights until this litigation is resolved. It's that they're not even being held accountable for violating a court order until the Supreme Court decided this issue. So let's turn to the birthright citizenship case. So that also involves this interim relief, these injunctions, except it's a slightly different issue, which is not just about whether an injunction should issue, but against whom. So when people file a lawsuit, there's plaintiffs to the case, and obviously they are the ones affected by the law that they're challenging. An injunction will definitely be applied to them. What we've seen with increasing frequency over, the last decade, I guess, are courts issuing something called universal injunctions. So they get a case from, plaintiff or group of plaintiffs, and they not only say, yes, we need to pause the law and it can't be enforced against you, but it can't be enforced against anybody anywhere. So one example of this is the travel ban, if you'll remember, from 2017. And some of this sort of is intuitive, right? Like that even if this case was filed in Hawaii, maybe it didn't make sense that it would only apply in Hawaii. Like if you're saying that the travel ban is unconstitutional, that you would need to pause that from going into effect across the country to sort of keep some uniformity. And so this seems to be the rationale behind these universal injunctions. So that was what happened with the birthright citizenship case, that there was a universal injunction that was put in place against Trump's executive order that basically reinterpreted the right to birthright citizenship that is enshrined in the 14th Amendment to the Constitution, and goes against longstanding interpretations of the 14th Amendment. And so the courts that heard this basically were like, not only is this crazy pants in terms of the legal claims, but we're going to pause this everywhere because obviously this needs to be, uniform, and it doesn't make sense for this to apply only on a case-by-case basis. So that was the issue that was before the court. It wasn't actually the 14th Amendment claim. That's not what they were deciding. They were deciding whether courts have the power to issue universal injunctions as a form of interim relief. And on that issue, Justice Amy Coney Barrett basically says, no, courts don't have the power to issue universal injunctions as a form of equitable interim relief. And she bases this on history, and they go into sort of some originalist interpretation and to substantiate this. Now, you might think, well, then what happens? I mean, in the birthright citizenship case, for example, if an injunction can only apply to the person who's suing, it would mean that anyone who's affected by the law would need to go sue in order for that EO to not apply to them. And that was really the argument that the plaintiffs were making when they argued this in front of the Supreme Court. And what the Supreme Court said is, well, that's what class action lawsuits are for. And so under the federal rules of civil procedure, there is a way to certify a class of people who all share similar characteristics and who are all similarly affected by a law. It takes a little bit more time. You have to define a class and make sure that, it's the criteria to meet it are all specified. But a district court can certify that class, and you can, to some degree, practically speaking, achieve the same outcome as a universal injunction. How easy it is to do that may depend from case to case and the issue that's involved. But in the case of the birthright citizenship challenge, there has already been there were lawyers waiting to file a class action lawsuit anticipating this result. And so the big takeaway here is the court actually hasn't made a final decision on the merits of the challenge, of the 14th Amendment and the interpretation and how it applies. It's only made a decision on, it's a procedural issue on whether the courts, how they can apply and to whom it can apply a pause, an injunction, against the law, against the executive order taking effect. So that is today's Ask Asha. I know it was kind of wonky and like very procedural and technical, but I think that it's important to understand because sometimes we hear that the Supreme Court has, ruled something or issued something, and we think the Supreme Court, that's the final say on X issue. But when you're dealing with these interim, relief orders, it could be just kind of making a decision on that, and the underlying litigation has yet to resolve. And in both of these cases, that is what is happening. I hope that makes sense. And I will be back. Thank you, Genevieve and Michael, for your questions. And I hope that I can answer some more in the coming weeks. Take care.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.